2 o'clock, no?
My lords, I appear for the state, my lords.
Oh, you're for the state, is it?
My lords, earlier I was appearing as well, my lords. I was not muted. So, my lords, if I may just apprise, my lord, regarding
the petitioner is missing. Petitioner's counsel is missing.
Oh, okay, my lords. But my lords have raised a query regarding the status of the trial, my lords. My lords, till date, no witness has been examined. However, it is at the stage. However, my lords, it is at the stage of examination of witnesses, my lords. The summons have been issued to the witnesses. They are not turning up. So, and he has one criminal antecedent in
But charge
Maharashtra.
sheet was filed in September 24.
Yes, my lords. And the charges
Then
of
not even one witness has turned up.
nothing, my lords. No one has been examined. I just got a written instruction from the state, my lords. None has been examined till date.
Past cases in Maharashtra.
Yes, my lord. That I have to confirm, my lords, because
That's
it is
what
written.
the order records, perhaps.
Yes, sir, my lords. That order records, the High Court's order records, my lord. Okay. It is para 4 of the Honorable High Court's order.
No, but why is the court not taking steps if the witnesses are not turning up?
My lords, that I have to see the order sheets which I have not received. This is the written instructions from the prosecutor there, my lords, which I have got.
Notice then you file a detailed affidavit.
My lords.
Your matter only. They've not, trial has not started till now. Delay condoned, issue notice. Hon'ble on 15. So and so takes notice and waives.
Please, my lords.
18. 18.
Which one is it?
One. Morning also no one was there.
May it please, Your Lordships.
Yes. Yes, Mr. Noli.
Please, Your Lordships, one sec. My Lordships, in fact, that's a public. The petitioner herein is, say, the municipal corporation, Your Lordships. The dispute is
921 days delay in filing.
Please, Your Lordship.
Not a criminal matter. Why should we? Plus 34 days in refiling.
No, the difficulty is it's a public road.
You're improving your case as you go along. Before the in the first appeal, you come up with some documents which don't really help you. You say that there's nothing in this, Mr. Noli.
My Lordship, at best,
you want the road, you acquire the land. On the face of it, you seem to have nothing to offer. You say there's a layout, but you don't have any approval of a layout to prove.
My Lordship may at least observe that, okay, that we will acquire it and pay the...
We are not opening those. We are not even condoning the delay. We find no grounds made out to condone the inordinate delay of 921 days in the filing of the special leave petition, coupled with a further delay of 134 days in its refiling. Even on merits, we find no grounds to interfere. We condone delay petitions, and in consequence, the special leave petition are accordingly dismissed. (26). Yes, no one.
May I please, Your Lordship?
Someone ask for 26.
Am I audible to my lord? 26.
Yes.
Am I audible to my lord?
Yes, Mr.
Yes, ma'am. But pursuant to filing of the special leave petition, the respondent company has been admitted into CIRP. Section 7 petition has been admitted by the NCLT Delhi. So, my lord, I would only request if this matter can just stand over for my lord, because they have now taken that in appeal before the NCLAT. So maybe that, subject to whatever may be the outcome.
Section 42, you yourself invoked Section 9 jurisdiction at Rewari.
My lord, if I permit,
Section
my lord, if I
42
may be permitted.
directly applies. Even if Delhi had jurisdiction, you yourself chose Rewari for filing your Section 9.
My lord, there is now enough sufficient case law on seat and venue. But my lord, on the maintainability aspect,
Whichever court first strike, that's it.
My lord,
Section 42, once you went before the Rewari court and invoked the Section 9 jurisdiction, that stands frozen there.
My lord, I am not. I was not addressing my lords on merit, but if my lord directs me, I shall. My lord, because for the reason now, Section 7 petition stands, like I said, admitted by the NCLT in all proceedings.
This order is concerned, we find no grounds to interfere.
So therefore, my lord, then allow me to make my submissions on merits, please. Then, if my lord is inclined to hear the matter, I will, because there is a bar in law by virtue of Section 7. I was not addressing my lords on merit. It was my duty to inform my lords at the outset. But
dismissing this matter.
No, my lord, then kindly hear me.
The Section 7 coming in our way now.
Then kindly hear me. If that is, my lord, then kindly hear me.
This remains after 42.
My lord, 115. Section 115, my lord, there are
115, 227, that argument won't stand, Mr.
Allow me to kindly explain. Kindly. My lord, there are 3 direct judgments of this court. Sadhana law,
those kind of
judges of this court.
We are not going to interfere on that count. No.
My lord, allow me to please present it. Kindly allow me. My lord, there are 3 judges on this honorable court in Sadhana law have clearly said there is a bar and it is not permissible to invoke jurisdiction under 227 of the, and once a remedy under 115 is available. The reason this company chose 227 was because they were in delay of in excess of 900 days. Therefore, skirting that issue, they chose to file a 227. Can I just show my lords that relevant paragraph, please? Para 15.
Even if you have a point on that, we'll say on facts, we are not inclined to interfere.
My lord, allow me to present it, please. Allow me. My lord, I have a very good case. My lord,
you sealed your fate by filing the Section 9 before the district judge at Rewari.
My lord, I have a reply to that. And let me say this. My lord, Section 9 was also filed in Delhi.
My judgment as a High Court judge is against you on this count. So I can't take a different view now.
My lord, I have not had the occasion to look at that judgment. Kindly allow me to look at that judgment. And I will be able to maybe make an effort to satisfy my lord. Maybe, my lord, facts of that case may be different.
To interfere with
my lord, kindly hear me.
By the High Court, especially.
My lord, please hear me. My lord,
we are not going to interfere with this.
My lord, kindly hear me. I'm just seeking my lord's indulgence to hear me. After that, whatever view my lord will take, I bow down to it. My lord, just kindly hear me. My lord, I think a litigant has...
227, 115, all right, we agree with you, but on facts, we are not inclined to apply.
Okay, my lord, if satisfied on that aspect, then second aspect, can I address my lord on the second aspect, please?
What is the second aspect?
My lord, on the aspect of whether on 42, my lord, there is a parallel Section 9 was filed in Delhi. Also, second, 50 sittings of the learned sole arbitrator, the former Chief Justice of India, took place at Delhi. The stamp paper was bought in Delhi.
When was the Delhi Section 9 filed?
My lord, I will just give the date, please.
Earlier one was at Rewari.
Yes, my lord, there are 2 Section 9s filed. And my lord, then...
Where do you get the details of this?
Sorry?
Where do you get the details of these 2 sections? Both filed by you, is it?
Yes, my lord, both were filed by me.
Why 2 separate courts?
My lord, because the second time when I went to the Chandigarh High Court, Section 11, my lord, for seeking an extension, my lord, the Honorable High Court did not permit me and said the relevant court would be Delhi. So I was relegated to Delhi High Court, where I filed Section 29A.
You've been going back and forth.
My lord, I was no. The High Court sent me away. The Punjab and Haryana High Court said, we will not entertain 29A, and you go to Delhi High Court. They sent me.
A invocation is also before the Punjab and Haryana High Court.
Sorry?
The 29A invocation is also there.
No. 29A, there are 4 applications before Delhi High Court. There are 4 applications before Delhi High Court.
First one is the Section 9 that you filed on 14th May 2015 before the district judge at Rewari.
My lord has paragraph 5. My lord has paragraph 5 of the order.
The first one is on 14th May.
I'm pointing out, requesting my lord to read paragraph 5, please.
Paragraph 5. Yes.
Thereafter, respondents filed another application under Section 29A before Delhi High Court, which was the third application filed by them.
Later, much later. Before
Yes.
that,
Before that, please have para 4.
2015.
Yes, yes.
14th May 2015, you went before the district judge.
So, my lord, just the prior page and right at the top, page 4, first line, an application under 29A of the Act before this court and wide order dated 29/9/17, an extension was granted by the coordinate bench of this court on the basis of the consent of both the parties. Thereafter, the arbitral proceedings could not be concluded within the aforesaid extended period of time, and another application for further extension was filed before this court, which was withdrawn, wide order dated so and so, with liberty to take appropriate remedy as available in law. Both the aforesaid orders, that is P8 and P9, are reproduced hereunder. 5. Thereafter, respondents filed another application 29A before the Delhi High Court, which is the third application filed by them, which is P10. And the same was allowed, and the time was for concluding the arbitral proceedings was extended.
This is all much later, Mr. Yadav.
My lord, so therefore, I have demonstrated that these are running in parallel. They have run in parallel.
Entertainment of these parallel proceedings itself was wrong, because once the first Section 9 was in the jurisdiction of Punjab and Haryana High Court, there ends the matter.
My lord, may I just point out one last fact, my lord? If I'm not being able to persuade my lord on 115 and on this aspect, may I just place this, my lord? Lastly, my lord, in BGS Soma, my lord, it has been said wherever the seat is not defined and the venue is defined, that is the court which will have the jurisdictional right.
Therefore,
lord, in this,
accepting that, if you had a choice of two, and you made your option by filing your Section 9, the first Section 9, on 14th May 2015, your fate stood settled there. That's all there is to it. All facts we find no good ground and reason to interfere with the impugned judgment passed by the High Court, the specially petitions accordingly dismissed.
My lord, may I seek the liberty to withdraw it then, my lord?
No, we do not permit withdrawals, Mr. Yadav.
Very well. Thank you. Very kind of my lords to have heard me. Thank you.
28. 28.
Malads, am I audible, Malads?
Yes.
Malads, award, the question framed is at page 127, Malads.
One moment.
Please, Malads.
Yes. Yes, Ms. Welby.
Please, my lords. My lords, the question framed by the tribunal is at 127. For a minute, my lords can kindly see.
Yes.
First question in para 22, my lords. Whether the claimant retired from partnership deed after receiving 1,65,000 from the respondent. This was the question frame, or the issue number 1. On page 129, after examining everything, and particularly 2-3 paras on 129, middle of the page, from perusal of this retirement deed, that's how it starts in finding, on maybe 8-10th line from the top. From perusal of this retirement deed, that's how it starts.
Page 129.
Yes, Malas. This is the finding on first issue. From perusal of this retirement deed, it is clear that... I'm sorry, Malas have got it, Malas?
Page 129 on perusal. I don't find it there.
Malas, it's 8th or 9th line, middle of the line, from perusal of this retirement deed.
Oh, from perusal. All right. I was looking for on perusal. Very well.
Oh, I'm sorry, Malas. I'm sorry.
From perusal.
From perusal of this retirement deed, it is clear that nothing was paid by respondent number 2 to claimant. Though claim of respondent number 2 is that rupees 1,65,000 were paid to the respondent number 4 and the claimant. It is the case of the respondent number 2 in his cross-examination, which will be decided later on in detail, that the accounts were settled by the claimant. It is admission of respondent number 2 in retirement deed that all the records shall be with the respondent number 2 and other respondent. If the account was settled, it should have been placed on record, which respondent number 2 failed to do so. Very material facts have not been mentioned in the retirement deed, etc. That the amount of 1,60,000 was paid. My claim was that the retirement deed, which was not acted upon because I was never paid this amount. Based on this, I succeeded the tribunal to say that I have not retired from the partnership. 34 court frames a question which is completely
retirement
different.
Deed is signed by you.
Yes, it is. I'm agreeing.
Wait, 155.
1235.
155.
155.
Para 41.
Apart from, just see it from apart from.
Rather, if we see 154 for a minute also. 154, para 37, it is by 34 courts.
Please, Mr. Balbir Singh, wait a minute.
Sorry.
Then
Page 155 and 156, where you admit your signatures on the retirement deed.
Yes, this was always my case. My case was never.
Your claim was that you had signed on some blank stamp papers.
That is the subsequent.
Of it was not believable at all, because given the atmosphere there, you would hardly have signed on blank signed papers when your mother.
I'm not. My case is not.
There.
Kindly see the question framed by the now High Court, para 37, page 154. My case was never that the deed was not signed. My case was that deed was not acted upon. 1,65,000 was not dispersed to the partners who are retiring. As a result, the partnership sustained. What 34 court frames is para 37.
Yes.
Thus, the principal question to be addressed by the arbitral tribunal was whether the BK IM had signed any blank papers which had been subsequently misused to reflect his retirement. This is not the question. I never claimed that.
then
This was in
his
context
claim is for the money.
What was your claim for then? Let us show it.
Yes.
Let us
Yes,
see your
Honorable.
claim.
That's the reason my claim
Let
was.
us see your claim statement. What exactly did you say?
I can read from the award, if my lords kindly allow me
File a
to.
copy of the claim statement. Very well. Let
Well,
us
I can
see from
file-
the award itself.
If we can come to
Award also is not there.
award is there. That's the
No,
question.
If it has been filed.
One page.
Part of it deals with your claim. Let us see.
Yes, page 125, para 17, Malaz, and 17 onwards is what I have said. And probably the confusion which created was the form 5. My case is not a form 5.
No, but your claim seems to have been that you are continuing as a partner there.
Yes, that's what
On
I'm
one
saying.
hand, you say that I never signed a retirement deed. I signed on blank paper.
Just see 116 and 117.
Kindly see one page 125, para 17.
One 116 and 117. This is what you said. Never discussed with him about the retirement from the firm.
Yes, so just to clarify what the confusion is created about the unsigned.
According to claimant's firm. Not
Para
claimant.
17 on page 125.
So you could have only sued for the amount which was due to you under the retirement deed. There's no question of your taking these kind of contradictory pleas that I never signed a retirement deed. I signed on blank stamp papers.
I signed.
And then saying that no, this amount is due to me.
No, this was never a case because this partnership we are existing is the second generation partnership. The parents of the partners were partners. I'm partners for generations in this. What was decided was that if you want to Page,
We are not inclined to interfere with this.
well,
Mr.
page
Balbir.
125. Kindly see
Both the
only
34 court and 37 court held against.
the wrong question framed. Absolutely. I'm making a statement. My claim is not that the deed was unsigned. Deed was signed. It was a form 5 which was the unsigned.
बैलून्स जो जा रहे थे अभी वो उनके तरफ से होता है या अपने तरफ से होता है?
It depends on who punched that, because there is a one icon which
You
will
seem to have done it, Mr. Balbir. So I was wondering why you're sending up balloons when we are about to dismiss your case.
Well, I have not touched that. So possibly my lords are using something which the balloon, and I have not seen it was visible to my lords. So possibly the screen working in my favor, I would say. First, just to clarify,
There's nothing here to interfere with.
I'm first of all, the question which has been framed by 34 court, I'm admitting right from the day one. It was this document of deed which was signed by me.
Oh, you were not very clear as to what you went before the arbitrator with. Deny your statement, then you say my amount is due under the same document.
No,
So
but
the
this is
arbitrator is also left clueless as to where he should go.
The award is very clear.
That
Kindly
award
see-
was doomed from the word go because of your lack of consistency.
The award is in my favor. So let's me make it clear. The award is my favor.
Award is in your favor, no doubt. The 34 and 37 both held
Yes.
against you there.
My finding will come from page 125. Only two paras. That will make it clear. Page 125,
Yes.
para 17.
Yes.
According to claimant, he is still legal partner of the respondent number 1 and entitled to all assets and property of the respondent number 1 as per the shares in partnership deeds. 18. Now this is important, Malas. Defense put up by respondent number 2 in his affidavit in evidence as well as in reply to claim petition is that the claimant, having retired from the respondent number 1, has no concern with the assets owned by it. According to respondent number 2, at the time of retirement, account of the firm was settled and amount due payable to the outgoing partner were paid. According to respondent number 2, claimant and respondent number 4 were each paid a sum of rupees 1,65,000 on retirement. The retirement deed was drawn on 19/1, which was duly signed by the claimant and respondent number 4 on 19/1/2020. My case was this deed which was signed by two partners, they never retired because this amount was not dispersed. The accounts were thereafter maintained continuously.
Once you signed it, if the amounts were not returned to you, then you file a suit for recovery of money.
Because subsequently accounts are maintained based on a partnership deed share. I still hold 33% share in that partnership.
However, we find no good ground and reason to interfere with the impugned judgment passed by the High Court, especially petitions accordingly.
Very well.
The 858.
May I please, Lord? Well, this is a contempt petition similar to what my lord had decided on
Yes,
the Telangana matter.
Who appears for the respondents?
The office report service
My
is
lord.
complete by all modes.
My lords, we've just filed a wakalatnama today. I'm awaiting instructions. I'll file my affidavit in a course of 2 weeks, my lords.
Please look at
I'm
the
slightly
judgment which
opposing
we have
the-
referred to. We have referred to a judgment in the notice order.
Indeed,
My
Lord.
lord.
That
That
this-
would squarely apply to you, so you can advise your clients
My
accordingly.
lords, I will. My lords, 2 weeks we'll file a compliance most likely, my lords.
And counsel appearing for the respondents. Takes time to. Yes.
But I just want to make one request, my lord. Post the summer vacation, the next academic session will start. So all that I'm requesting is this, my lord, because the order originally was of October 25, had to be complied by January. Of course, review petition, etc. I won't take my lords again through that because in the Telangana matter, my lords have seen. Can I just request, my lord, that kindly give me a date this side of vacation so that they can report compliance? Because if it comes after vacation and we do compliance after summer break,
That
I will
would
lose
give the
one
council
academic.
only a week's time then.
My
Can
lords
you
may
put
have it
the-
on Friday, my lords, the last day of vacation. I'll
That's a
file
very
my
fair
affidavit.
submission to make, my lord.
This
I'm
one.
grateful to my learned friend. Lord, and one query, my lord, had put that those balloons come because of the victory sign. Whenever there'll be a victory sign on Apple, my lord,
I
by
see.
anyone, so the balloons will come. My lord had put in the last matter, why were the balloons coming?
I did not make a victory sign, and Mr. Balbir was not inclined to because we
So,
were
Lord,
going to
whenever
discuss
in Apple
that.
there'll be a thumbs up or there'll be a victory sign, then balloons will come. That is the
Why is-
Apple
Why is it
problem.
not happening now then? You did both.
So I have turned it off so that there's no distraction.
Well, Mr. Balbir, you must have done it there.
Possibly. So grateful, my lords. My lords, We'll have it on the last day of
Yes,
vacation.
29.
I'm so grateful, my lords. Deeply grateful.
59. You are for?
My lords, I'm an intervener in item number 59.
These applications now, to begin with, other concessions in para 49 would have application only to disabled candidates. The sentence does not lend itself to the interpretation that other concessions should be extended to all untainted candidates. That's not how the
Lord, I'm appearing in 59. That is a contempt petition.
That many applications were moved, Lord. Lordship was kind of dismiss all. They're trying to create trouble by making
And
these
we never-
applications.
we never
That
said
is my
that.
submission also. I am in 59.1.
So,
They-
Lord,
this is
59.1. I'm for the petitioners. Lord, 59.1. May I submit, Lord, with great respect. Lord, this is
Yes.
one selection where all the well accepted norms of recruitment have been transgressed.
No, we are not arguing the main case
all
here.
over now. Case is already
I
over.
direct-
We are not arguing the main case.
We're not
Question is
going to
whether there is
reopen
con-
anything.
All these points were argued. 185
However
review
many
applications
people
were
you may be
dismissed.
representing.
But in the contempt matter,
Not in an
I'm
expiry
appearing in the
If
contempt
you're
matter.
not there, you're
I'm
not
seeking
there.
anything.
You were an
Malas, I'm
unpaid-
representing a teacher, Malas. He's
If you're
75%
not-
blind, Malas.
if you're not
He's
participating
57
in the
years old,
special
Malas.
elections.
Lord, in the
Because therefore,
contempt
Malas, we
matter-
want a Malas clarification on the conditions, Malas.
That's all there is.
75% blind, Malas, and Malas 57-year-old, Malas.
Contempt petitions are pending.
I'm
No,
not.
all these points were argued
Contempt.
Lord,
I'm
long
doing the
back.
clarification, Malas.
Lord, may I submit with great respect? Lord?
We find no grounds to
Yes.
entertain these applications filed for clarification. What are they called? Clarification of the judgment dated.
Malas, may then allow me to withdraw the application for clarification, Malas.
I'm deep located.
4800
I'm not
2025
persons
and
who are asking for clarification. I'm not for them. I'm against them because they have listed me in a list.
First of
where
all, there is a
I'm being
contempt
shown as a
petition.
tainted
Lord,
candidate, my lords. I'm
Lord,
not.
contempt petition first.
there's no question of our going into it because that issue was never before us.
Go down to that, my lords. I
If you had raised the only one candidate who did have a case in that
my lords,
Yes.
very well, my lords.
in that issue on that issue was a person who had filed a writ petition even before the closure of the case by the Calcutta High Court itself.
Right,
That
right.
That was the
Single
only case we said her case alone requires to be examined because we never went into the issue as to who is tainted, who is not tainted.
Exactly, my lords.
So if you ought to have raised it prior to this
Absolutely.
happening.
My lords.
Because before us, everyone was certain as to whether they were tainted or not tainted.
Totally
That
agree.
is
Because
that
they
is
all-
why, Lord, we are in
council all stood
we are
up
in a
and
contempt
for the
petition.
untainted candidates. Now you can't say that there was a doubt and we want to reopen that issue now.
Absolutely right.
Very
Lord.
That as a matter
Lordships
of
will
routine, these
observe
applications
that
are
till
filed.
the final
All-
process is
all
over, your
applications are
lordships, no more
Malas, second issue is,
applications
Malas, they have,
coming.
Malas,
Lordships, because this
Not
delays
in
the
one
process all
59
the
point.
time.
Malas,
That
can I
is
just
just one thing.
can I just be
Malas, the
heard
second
for
issue is, Malas, the number of,
petition.
Malas,
At the same time, I
candidates for
can't
a
make
particular
out a single
category
thing.
that has been, Malas,
So we'll
altered by the,
go with
Malas,
ladies first. So
department,
Ms.
Malas.
Makija, yes.
Lord, 59.1 is the
Are
contempt
you a
petition.
lady?
Lord,
Ms.
59. I am
Not a lady. I said ladies first. Ms. Makija goes.
all right, all right.
Yes, your lordships,
Yes, Ms. Makija.
all that I'm praying for is that these applications and contempt petitions are repeatedly coming through different people on the same grounds. Your lordships may kindly observe that till the time that West Bengal Service Board finishes the recruitment, no further application should come, your lordships. They are all on the same
We
grounds.
can't,
On
we
a
can't
previous
stall the
occasion,
filing of applications.
your lordships may then observe that the recruitment must go on, your
That
lordships.
we have not stated. Where's the question of it not going
There
on?
is no stage.
Lordships,
There is
because
no stage.
every time
We can't stall the
application
filing
comes,
of
the board
cases. That's not
places
right.
them.
It's a
Yes,
Yes, your
next.
lordships may kindly say that the recruitment be completed
But these
as
are all
was stated
frivolous
by your
applications.
lordships earlier, by
Anyhow,
31st
we can't
August.
stop the filing of
Lordships
it.
have given that
Ms. Makija.
deadline.
Let's see what.
link has been sent to 800 people, my lords, who are listed wrongly in this clarification application, my lords. They have not listed an order that is dated 7th of 7/7/2023.
The later one.
Yes, my lord.
Allowing the untainted candidates.
This list of 5757 people, my lords, where 2-3 recommendation letters are there. They have not attached the Gazette notification of 2016, my lords, and they are coming from.
Anyhow, we are not entertaining anything. Yes, Mr.
My lords, if I
Masudi.
just Lord, with great respect, Lord, the transgression and the rampant illegalities which were noticed by the Honorable Supreme Court, Lord, I invite my Lord's kind attention to page 77 directly. It's a small paragraph, Lord. May I be permitted to read it out? The claim that the data on the 3 hard disks shows no interpolation and is consistent with the data in Messrs. Data so-and-so solutions computers fails to account for significant gaps and discrepancies. These issues highlighted in both the impugned judgment and our findings clearly point out to large-scale manipulation and tampering with results, including rank jumping, discrepancies in marks, the issuance of appointment letters to candidates not on the panel.
What do you want from that now?
Now, my Lord, this is what has been noticed and what finally the Honorable Supreme Court, my Lord, approved and affirmed the judgment rendered by the High Court. Now, our grievance is, my Lord, I have taken up the matter in 2 parts. Now, these 4 categories, in paragraph 28, if your Lordship may have at page 28, what I say is that the Honorable Supreme Court, with respect to the appointments, when it applied mine, it found that 6,276 candidates who were tainted were appointed and their appointments were quashed.
We never mentioned any numbers, but anyhow.
Yes, your Lordship may kindly have the numbers are there in paragraph 26 of the...
If I can make a preliminary submission, these very people had first filed one IA before the registrar. The registrar refused to entertain it. They withdrew it.
Because there is a question which has
just 1 minute.
As to the figures.
Just 1 minute. They have filed a second IA before your Lordships and sought permission to withdraw it. And now this contempt, it's a misuse of the process.
No, it's not. It is simply we are not going for the multiplicity of proceedings which have ultimately been settled by the apex court in great clarity. No, my lord, the figures your lordships were pleased to ask me. Please kindly have not page 70. Page 70, your lordship may kindly have at the bottom. The figures are disclosed by the apex court in its judgment. Lord, last paragraph, Lord, in the last part of this page 70, Lord, the apex court says, records that the commission claims that 57 Group C and 107 Group D selectees, appointees with OMR mismatch were not recommended but appointed. However, their names also figure in the list of appointed through rank jumping and out of panel. Now,
where are you reading, Council?
Page 70, Lord.
Page 70 of 59.1.
This is paragraph 26 of the apex court judgment and page 70 at the bottom, Lord.
Yes.
Where WBSCC claims. This is the commission, Lord.
Yes.
Now, Lord, in this paragraph, the last sentence begins. The commission admits that
1,057 group. Then
an admission is not.
No, this is an admission of the commission.
We have not said anything.
No, next page. Lord, on page 71.
So illegal appointments were made.
On page 71.
We have never gone into the numbers or decided who's tainted, who's not tainted.
Kindly have page 71. Kindly have page 71. Please turn this page, my lord, then your lordship may have. Thus, excluding 239 candidates who fall under both OMR mismatch and other illegalities, Commission acknowledges that 6,276 illegal appointments were made.
That's the Commission's acknowledgement.
Out of this 6,276, what they have done is what I have stated in paragraph 26 and page 28. Out of these 6,276, they have notified the illegal appointments, finding them tainted candidates, confining them to 5,318. And 958 candidates are nevertheless.
When we have already said that all issues will be raised before the High Court.
That
So
is
whether
for
the
the
question of again
They
coming back to
applications
They have
are
raised
filed.
it. Their writ has already been dismissed. They raised this petition. They filed a writ. Writ is dismissed.
Oh, writ is
They came in SLP. SLP
Malas,
dismissed.
One,
it.
it's
How this can
few applications.
Candidates was dismissed.
All these were
One
dismissed.
clarification, Malas.
or the contempt
Kindly
case
dismiss this
filed.
application.
My lords, if I just,
Judgment dated.
my lords, if I just,
One last submission on the clarification. Malas.
Two contempt petitions regarding the same judgment.
Batch.
Notice
The
was
applications
issued.
as well as the contempt petitions are accordingly dismissed.
The original contempt is pending.
My lords, if I
Filed
just
by
may,
us. Why this
The
contempt?
contempt petition is pending before this court.
That is for a totally different issue. It has nothing to do with this.
These contempt petitions we are dismissing. They're in-
my lords, if I just may mention item 59.3 I pair for the applicants in that matter. We circulated a withdrawal letter on Friday. That is on
What exactly is that? Is
16th
it
of
an
May.
application or a contempt petition?
Same application, Your Lordship.
It's an application, the same as
seeking
contempt.
clarification, my
What
lord.
of it, right?
We wish to withdraw. We circulated a letter on
It's
Friday.
an intervention application in that clarification application, my lords.
You filed an intervention.
Yes, my lords. And
So
that
now they've get them enough to want to withdraw it.
My lords, with due respect, I would just submit that we've not gone into the merits of the case, therefore they have no locus.
We are not going to give you any liberties.
Yes.
Be certain about that.
Your Lordship may kindly bear with me for a second. The same contempt matter on one facet of the
This
same
main application, where is it? MA. This is the IA in. This is the very good. MA number 26462 of 2026, Mr. Varun Rawat, Learned Counsel, representing Mr. Jain Nami. This Mr. Jain
Miss Namisha.
Anuj. Man or woman?
Woman,
Namisha
sir.
Anuj Jain, my lords. Namisha Anuj.
Oh, it's Miss Namisha Anuj.
Miss
Jain.
Namisha.
Miss Namisha Anuj Jain seeks permission to withdraw the application filed for clarification. The application is permission granted. The application is accordingly dismissed as withdrawn.
Very grateful, Your
Lord,
Lordship.
the last submission, Lord,
Grateful.
Your Lordship may kindly have page 401. Just for
Your matter is already over, Mr. Masood.
just one second, my Lord, if Your Lordship.
I deeply obliged, Lord.
We are not
Appreciate
going to
indulgence if Your
repronounce
Lordship
Very
may
grateful,
kindly
Lord.
grant.
Grateful, dear.
over now.
Grateful.
That's all. Item 60.
Please allow us to appear physically, my lord. It's
Yes, Mr. How did you get here?
but we were in chambers.
How did you get to the chamber?
Is not prohibited. Even your lordship's doors are open. Since we were in chambers, some other councils were repairing. My friend has come from Bangalore. He thought that we should go there.
Everybody is driving to the chambers within the Supreme Court, but you're not coming inside and arguing, is it? What is the logic? I thought the entire logic was nobody would come to the Supreme Court at all. But all of you have your offices here.
Full of cars.
Oh, what the point is it? Anyhow, so you are here. All right.
We are grateful.
Yes,
My
Ms.
friend
Gupta.
Bangalore, he wanted to, my lords, come physically, so we have.
Yes.
Now, my lords, please have page 227. Lords, I have an eviction decree against me. The
But
mean
this
profit-
affidavit that you file, you try to be a little too smart for your own good.
I'm not.
If the High Court says file an affidavit saying that you're going to vacate these 16 rooms, you can just say pursuant to that order, I'm vacating. Why do you have to say this is only because out of respect for the order of the High Court, this does not foreclose my rights? Your appeal is pending anyhow.
Clarify.
So why do you say all these things?
Is right, but I want to clarify. If after this chronology, if your lordship feels that we have to change our affidavit, we will.
Look at your affidavit once, 238.
Can I show 227 once? Permit me, my lord.
227.
High Court 227. That's 18th December 25 order against which my SLP is dismissed. So I want to show this order, my lord. Now, in a first appeal, I am asked to file an affidavit to vacate before adjudicating the appeal. But that's all right, my lord. Please see the last 4 lines. The admitted rent shall be paid on or before 5th of every month. This order is without prejudice to the contentions of the parties. The appellant shall place on record the affidavit in terms of this order within 3 weeks from today. The affidavit had to be without prejudice, my lord. My first appeal is pending before the Honorable High Court. Now, my lord, I come to your lordship. Your lordship.
The order already records it. Why do you have to say it in your affidavit again?
Something else. Now, I'm saying something else. Lord.
This order records that whatever you do is going to be without prejudice to the contentions.
So the prejudice I will show. Just give me one more second. My lord, in all fairness, your lordship dismissed our SLP against this order at page 235. Because we were wanting to say that, my lord, the appeal cannot be prejudged during pendency of my eviction.
You're a sublessee. You're a sublessee. And your lessee's lease is over.
No, not yet.
That is over 26 June. End of June.
He has not said that Papanna has, my lord, instituted any suit against him, who is his lessor. So, my lord, now please see, after your lordship dismissed my SLP at page 235, I have filed the affidavit, my lord, at page 238.
Look at your affidavit, please.
Yes, my lord. Affidavit.
Not once, but again and again.
What does a party do? My lord, I am in an eviction.
Why do you have to do that? Anyhow, you are abiding by the order. Otherwise, the delivery warrant is already issued in the execution petition.
In my favor since the time
So you want the stay is conditional, then you have to abide by the condition. You can't again bargain over the condition and say that I'll file an affidavit, but I'll do it on my own terms.
Today. Let's please appreciate our problem.
Extend.
Let's please, I'm sorry. Please appreciate the concern of a litigant. He is in an eviction appeal. He said that before deciding your appeal, you have to file an affidavit to vacate. Now, my lords, even that I have filed, but
now what happened on the next day? 3 days time was given. That was long ago.
I have filed the affidavit. Now, please see the impugned order. I want to show my concern, Lord. What
impugned order?
Page 2. Page 2, my lord, is the impugned
Page
order.
2 is the 22nd April order, which gave you 3 days time to file a better affidavit. You have not filed it.
Lord, I want to show one thing. Lord.
No, did you file it pursuant to this?
Affidavit, because we have come to your lordship immediately. But please have my concern. Now that I have told all of this to your lordship, please have my concern. What does the Honorable High Court do? Lord, please have para 2 of this order. The affidavit by way of undertaking filed by appellant dated 25/2 is not in compliance with the directions of this court. Not the Honorable High Court also said without prejudice. Therefore, I added without prejudice. Let a fresh affidavit fill. Now, please see para 4. List on 13 July 26. And I am asked to vacate by 30th of June 26. Lord.
You have to vacate.
No, but Lord, my appeal having not
You
been...
can always go back into the premises again if you win.
This is not possible. Now, Lord, my request is twofold.
You're running a hotel anyway.
Restore your possession.
Sorry, my lord.
You think the High Court will not be able to restore your possession?
I'm not saying that.
You're running a hotel anyway. It's not like it's a...
But Lord, 48 rooms I already have out of those 16. Now, Lord, in all my humble submission, this is unheard of. Your lordship will never pass this order that in an eviction appeal, if your lordship...
the High Court imposes a condition, you are expected to abide by that order. All that you had to say was in terms of the order dated so and so, I'm filing the affidavit.
Lord, I
you want to be smart about it and say all these things, then obviously you are rubbing the High Court the wrong way.
This background I have given not for notice. I just want one single sentence. Lord, our concern, Lordship may hear and then Lord's dismiss. The concern is this. Lords, I will file a better affidavit. I will file an unconditional affidavit. Lords, the Honorable High Court is reopening on 1st of June. Since I have been asked to vacate on 30th of June, there are 30 days, Lords. Let my appeal be decided at least in the first week of June.
We are not going
to. Otherwise, Lord, this puts the card.
We are not going to fix a time.
Where does the litigant go? Lords, I am just wanting to say
you want a stay, is it not? Otherwise, the execution can go on.
I have a stay. Till 30th of June, High Court has not asked me to vacate.
But restored into possession.
Lords, but in an eviction suit, after having given...
find no good ground and reason to interfere with the impugned interim order passed by the High Court. Especially if petition is accordingly dismissed. The petitioner shall file an affidavit as directed by the High Court within 3 days from today.
You will do that. And Lord, then Lordship may at least...
Nothing more.
No, before 30th of June, Lord,
we are giving you 3 more days. Be happy about
it. Equities have to be balanced. Lord,
that is the equity. You get 3 more days time, though you did not file it within that time. 25. Okay, file it.
Get a stay on deposit of 75%. I deposit that, Lord.
Nothing more, Mr. Gagan.
Now, without a modification application, this stay order is modified to say that you file an undertaking before my appeal getting adjudicated. Lord, this in my...
File it, please.
Lord, this is
nothing more. Nothing more at this stage.
No, Lord,
nothing more at this stage.
For a tenant to come back, Lord, in the premises, Lord, is...
You're a sublessee whose lessor's lease is running out. Where's the question?
30 years and I'm running a hotel. These are meant to be long-term leases.
Very good.
Now, Lord, I have my remedy until this Honorable Court.
This lease deed is of 12th January 1990.
I'm only saying
Then
that.
where's the question?
Does that bar my appeal or an SLP? I'm only saying that decide my
At
appeal.
some point of time, you need to give back the property to a landlord.
But subject to the
You don't develop roots because you are a tenant there.
I'll tell you, Lordship.
But unfortunately, here all tenants seem to think that they can develop roots.
The problem here is this. One small
Some
problem.
point of time, the owner is entitled to get his property back.
So therefore, Lords, one small problem here on merits is this, which is why we were pressing that appeal should get decided on merits.
Nothing more. We are not going to fix a time frame. Be certain.
2 more minutes.
Nothing more, Mr. Gagan.
One problem I want to tell the High Court is that only 4 out of 9 landlords have come, Lords, under 108Q. I must give.
Raise all those issues there. We are not going to go into all.
But I must give back.
We are on a limited ground here. That's all. Over now.
But at least
Next.
a request to the High Court Lordships can make.
Next matter. Nothing more.
Request to decide 30th.
Nothing more, Mr. Gagan. Next.
Please, Lordship. Lordships in TT Anthony said there can't be
All
a
your
second
FIRs are in District Ahmedabad City. All your FIR.
Just see, in first principle FIR,
Be bothered within the same district to get bail orders, is it?
Lordship, just see, in first principle FIR, I have been granted bail saying that arrest is illegal and violation of 21-22.
Well, these kind of prayers.
When before I come out, second FIR got lodged.
Criminal law justice system is not there to serve the accused. Most of the accused seem to be under that impression. No coercive steps, not to do register FIRs, no arrest, no custodial interrogation.
No, principal FIR,
after
I
all
have been granted a bail saying that my arrest is illegal, detention is illegal, violation of Article 21-22. Immediately, second FIR lodged, I was taken over in that.
This many people for a ride, each of them is entitled to register a FIR, is it not?
Lordship Justice. Lordship in Amish Devgan and
nothing more.
Orela said.
If I know.
Orela is the Lordship Justice Chandran's
judgment filed under Article of the Constitution. The writ petition is accordingly dismissed.
Lordship, then kindly permit me to withdraw. I filed.
No, we don't permit withdrawal.
Dismissal
of this writ petition shall not preclude the petitioner from availing such remedies as are, invoking such remedies as are available to him in accordance with law before the appropriate forum.
Grateful, Lord. Great.
Yes.
Yes, my lords. I am appealing for the petitioner, my lords. In this case, my lords, the victim and the accused have married in the year 2024, my lords. And they are having a child of 1 year almost.
Returnable on 15 July.
My lords, stay on the trial because matter is listed on the 4th of July before the trial court.
What is the case number?
62, my lords.
Page 62. Which page is it?
Is not good. 63.
This one? Yes. But this is the case number, counsel.
My lords, sessions case 489/2022.
Further proceedings in sessions case number
489/2022.
489 of 2022 on the file of the learned additional sessions judge -01 within brackets POXO, Dwarka Courts, New Delhi shall remain stayed till the next hearing.
Please, my lords. Obligement.
Yes. 63.
Note 63, I appear for the petitioner.
Yes.
I think, but I'm just checking if Mr. Diwan was also appearing along with me. Otherwise, I can start off, my lord. Lord, this is that case, my lord, where the High Court proceeds on the basis that everything is a fraud in relation to the grant of an inam. But the short point we have for your lordship's kind consideration is, everything arises, my lord, from a mutation proceeding. The Inam inquiry grant happens under the Inams Act, which has a different hierarchy of authorities. My lord, they would decide whether it is correct or not. When I apply for mutation and they want to, my lord, change the mutation entry, a authority acting under, my lord, the Revenue Act only for mutation, which is a limited purpose, which in any event is not final. He proceeds to say that mutation will be undone because I find the grant of Inam is fraudulent. My lord, the High Court now willy-nilly, my lord, completely nullifies my right under the Inams Act, because even if I go and assert my right under the Inams Act, my lord, the Inam authority will now be bound by the High Court, which says that in a mutation proceeding, the Inam granted to me in 1966, my lord, is fraudulent and fake. This is not arising under the Inams Act. My lord, this is only arising, I'm sorry, my lord, Mr. Diwan is also here.
No, I'm grateful. My learned friend can continue. I've got some other points which I'll just place.
My lord, this is, my lord, I thought the most important point, that a mutation inquiry, which is for a limited purpose of only noting the names, cannot be used for the purpose of undoing, my lord, a grant made under the Inams Act in 1966. And my lord, each of the findings of fraud, my lord, the High Court, my lord, captures, I may be able to satisfy your lordships that each of this is completely incorrect by giving your lordships a tabular statement. But the larger point being, a mutation authority unconnected with Inam declares Inam to be fraudulent, and High Court, my lord, conducts a factual inquiry for the purpose of saying, yes, he is right and the Inam's grant is incorrect.
Yes, Mr. Diwan.
Manoj, may I just supplement this? Now, first and foremost, I would like your lordships to notice the impugned judgment. Just the date of the impugned judgment, which your lordship will see is 1st of December 2025.
Yes.
Now I would request the court to please take up, this is in form of additional documents, please go directly to page 701, Annexure P19. P19.
Yes.
Now, do your lordships have that bulldozer there? 701?
Yes.
Yeah. So this is, and you will see the date there. This is taken on the 9th and the 10th. The date marked is, date stamped is 10th December 2025.
Yes.
So the bulldozers come in, godowns are demolished. They just move into the property. I'm going to give you a little background thereafter, and thereafter they start certain construction activities, etc. Please go further on to page 709. Now this is February 2026, same property of mine. And then I'll just project the thing. This is a residential house. So someone comes and seals it, and it is being vandalized, as your lordship will see from pages 711, etc. onwards, immediately after this impugned order has been passed. So basically what's happened is that the state has taken the law onto its own hands, and this ought to be deprecated. And I'm going to request the court, if your lordships are inclined to issue notice, to also grant a status quo order, and then we'll come back with the further details. Now, who am I? So please just note this. So first and foremost, what I want to say about, as was indicated to the court, this entire proceeding arises from mutation entries in revenue records. The whole process is mutation entries in revenue records. Assuming that the mutation entries in revenue records, that something is found wrong, which I will tell your lordships is completely erroneous, I have a succession of title deeds. Now, may I just request your lordship to note a few dates? With your permission, may I just request a few dates?
Yes.
My title deed is registered, etc. You may assume that that is the case. Is 24th August 1982. Now I'm going to go backwards.
Just a minute.
Yes.
To notice, Mr. Diwan, Mr. Reddy.
I'm grateful. Manoj, may I request a status quo?
Yes.
Please, I don't want.
Notice returnable loan.
I'm grateful.
3rd August. Status quo obtaining as on date shall be maintained in all respects.
Grateful, Your Honor.
Grateful. Question. $64.
May I please, Manoj?
Yes.
Well, these are 3 petitions. One is by SIDCO, which is the Developing Agency of State of Maharashtra. Second is the KIDC, which is the agency through which the contract was carried out, funded by SIDCO. And third is the State of Maharashtra, Manoj.
Yes.
Well, this is one matter which I am reasonably confident will shock the conscience of the court. I'll start with what is wrong with the 34 per se. It is an award where 3:2 findings are there. So it's a tribunal of 5, 3 and 2.
Yes.
On the face of it, 34 to requirement of 34 on a perversity and illegal patent illegality. Page 313, which is the part of the award, Malas. On the face of it.
313.
Before I come, 313, Malas.
Yes.
On the middle of this page, Malas, a particular clause is given, which reads clause 70.3, because this is one of the big bone of contention, that whose responsibility is to secure the forest clearance. The award very clearly says, the contract very clearly says 70.3, responsibility of the contractor. The contractor shall have a responsibility toward the final clearance as mentioned in the all steps. The work of the dam shall not be started unless at least the principal clearance of forest land is obtained. The corporation shall extend us necessary help as and when required to the contractor. On this clause, what the tribunal says is interesting, Malas. As discussed earlier, applying for and granting forest clearance was a matter which was within the exclusive domain of the officers of a different department of the state government and the central government respectively. It is relevant to note here that the contract is a printed document containing several errors and inaccuracies. It is an old stereotype contract containing several clauses which are wholly inapplicable. For instance, then it goes on narrating few clauses. On next page.
Not only that, they specifically say that.
It doesn't end there, Malas. Interestingly, it doesn't end there. Page 314, last 4 lines on this. This contract, last 4 lines, this will render the provision of section 73 of the Indian Contract Act completely nugatory. We are only mentioning a few clauses which show a typical case of unequal bargain power between the contracting parties when printed documents running into hundreds of pages are signed without verifying the same. In an appropriate case, such clauses may be held to be in teeth of the provisions of section 16 of or 19 of the Indian Contract Act. It is not necessary to dilate on this subject any further. Suffices to say the complete non-application of mine and casual journal observations are made while issuing a notice without appreciating the ground realities. So they says what you have written in the contract is bad. Don't look at these contract under the Environment Act and the other regulatory scheme. The state executive, on the face of it, a clause and a contract are completely outside the contract, Malas. That's on the face of it. Second part, which is extremely important, Malas. In this case, if my lords can kindly, the very big, this was a project, Malas, for potable water, drinking water in a particular area was to be set up. SIDCO was the agency which was supposed to fund. KIDC was supposed to appoint a contractor, and a contractor was appointed, Malas. Initially, the value of contract was 350 crores, which was elevated to a level of some 1200 crores. Corruption charges were found. The government issued GR in this case, and that GR is available at page.
What is the GR?
Government resolution, Malas. The
government resolution.
Yes. The state issues those resolutions, and this is the GR is available at Malas Additional paper book I have filed, my lords. I'm sorry, I filed later. It's not part of this. If my lords can please call that paper book for permission to file the additional documents. This is running.
IA is 150454. That one?
Yeah, Malak, this is running into 219 pages.
My lord, may I come in, my lord? I don't have these additional documents. Allow me to, my lord, have a look. I don't have them.
This IA is not served on you, Mr. Rodgi.
No, my lord, I don't have it, my lord.
It's been served, Malads, to everyone, and then it has been filed.
Well, Mr. Rodgi,
there are three connected matters, my lord. 1 second, sir, 1 second. There are three connected matters, my lord. He has filed some documents in one. Impugned order is common. I want to have a look. The lordship may call it on Friday.
This IA is filed. This IA is filed in Sidco's matter only.
Malad, yes, Sidco's matter is actually irrelevant.
Diary number
1363 of I want to have a look. We are in a companion matter. Impugned order is same. Please allow us to have a look and call it on Friday.
Maladi, today.
That's all I'm saying.
My lord, let me point out one thing, please. Sidco's matter actually is the most irrelevant.
If you really want notice to be issued, notice can be issued.
Matter because Sidco, the award is only 15 lakhs.
It's not a question of the award.
It's KSIDC, which is the aggrieved party.
Mr. Sundaram, certainly you are not briefed. You have not been shown your writ petition. Kindly allow me to.
I'll deal with it.
Malas, I don't need to say anything more. I think
my objection is far more.
If they don't want to
in the SLP, I'll show
let them reply. Let them reply, Malas. I have no difficulty.
I am only saying, please allow me to have a look, my lord. I have no idea what he's talking about.
To Delhi High Court, where I filed section 29A.
You've been going back and forth.
My lord, I was no. The High Court sent me away. The Punjab and Haryana High Court said we will not entertain 29A, and you go to Delhi High Court. They sent me there.
DPRO, Karnal.
Operation of respective order.
Where is that? Where is that?
That is
continuously there.
No.
Yes. P18, 19, 20, 21.
Then the next order is
this one.
Order is 294. Lordship will kindly see page 294.
Who is your employer?
Page 294.
The state government, my lord. This I am appearing for the petition, my lord.
Here
I am seeking to.
And operative portion is on page 296. And the order is valid.
There's so many status quo orders.
And the order is my lord on a relevant portion is on page 296.
Before 28 May. Further proceedings of FAO number 36 of 2021 pending before the High Court of Delhi at New Delhi shall remain stayed.
Much obliged. Much obliged.
Please, my lord.
Madam Trivedi, not before me.
Please, my lord. Please.
Not before a bench of which DD is a member.
You are safe today. What I wrote, I'll not tell you.
Please, my lord. I am very aware. My apologies, my lord. I realize that.
This law,
Yes, 36.
My lords, in 36, there are two matters. I am for the landowner. Dr. Singhvi, who is waving his hand vigorously, is for the borrower.
But my lord,
He-
take the 36.1 file.
Ideally, 36.1 should start, my lord.
Yeah, you do also take the file of 36.1.
Who is the borrower? 36 or 36.1?
36.1 is borrower, 36 is landowner. 36 sought to intervene in the impugned proceedings. That was not granted. So 36 has an additional hurdle to climb, which is that I should be allowed my intervention. It's my land which has been put up for auction for the first time.
I am for the caveator. I am for the auction purchaser.
Just one.
All of you, just one clarification.
Yes.
Now, DRT and DRAT concurrently set aside the sale.
In my favor.
On the ground of fraud.
Yes.
Right?
Yes.
Now, the High Court of Bombay has allowed the writ petitions filed by the secured creditor and the auction purchaser.
Lordship, please.
And disposed of their petition with a direction to the DRT to consider the 17 application. Up to this, there is no confusion.
That's correct.
Yes,
That's
Lordship. Has the High Court not said anything about the sale? What happens to the sale?
Yes.
They have not said, Muluz, and may I just, I am the petitioner. Can I just take 2 minutes, Muluz?
Yes.
I've got a list of dates which is vital to show the fraud. Sent yesterday to the court master and again today. It can be handed over. Just note this, Muluz.
Color scheme.
I beg your pardon?
Any colored list of dates?
Yes, it's got colors in between. In between, it's got colors, Muluz, because that colors are to show the colored fraud. It's to emphasize the fraud. It will become very clear. Just give me 3 or 4 minutes. Now, Muluz, I am the debtor in the sense that I am a guarantor debtor. I mortgage the property on behalf of this loan. Now, Muluz, 5 dates are important in sequence, and that's enough to show the fraud. Muluz, there are in item 8, there are 6 failed attempts. Just note in item 8, 6 failed attempts, which is why the Lordship should be more suspicious when suddenly things are sold to Mr. Rodgi's client. There are 6 failed attempts. Now, in item 10, I filed 2 applications, one to injunct and one a formal amendment to bring on subsequent development. This is very important. I filed an injunction application prior in item 10. The date is before my lords. This is 8th May. Now look at the fraudulent action which starts on 10th and 11th. In item 12, which is 10th May, which is the red one. This is
we are not getting it.
Getting it. Or be pages hai.
List of dates. List of dates was handed over to your lordship. No, it's a list of dates. I don't know what.
We have flowchart 11th May.
No, Lord, flowchart is mine. I have circulated the flowchart.
Please give my list of dates, please. This is
I have circulated a colored flowchart to show how Lord the owner came, how the owner gave
Mr. Rodgi, this is not an opportunity for you to intervene. Please. I am the petitioner.
I am not intervening. I am only responding to the court's question.
What do you mean? We want Dr. Singhvi's list of dates. We have not got it.
Very sorry. Just the limitations of a virtual hearing.
Petitioner ka nahi aaya.
It says on top, it says on top. It says on top, briefing note.
Sir, we don't have it, sir.
I have a suggestion. In my first matter, if you just come to page D for Delhi, those similar dates are there, which will show what the fraud is. Page D.
No, but it may not be the same chart. So, I had prepared it on that chart, but let Mr. Gopal then do it, because I have no problem. Because my chart is vital to show. Can't the court master?
I have a preliminary submission. Let me place that if it meets with the lordship.
Or would your lordship do one thing, can your lordship take it on Friday? It's far too important, not to have that chart.
Don't mind. But I have a submission to make.
Senior counsel, if we can just find out a why.
So I wanted to say something on that.
17 application will be heard afresh.
Just give me 1 minute, my lord. I wanted to say something on the why media.
One clarification. The secured asset, who is in possession of it?
I am the auction purchaser. I have a confirmed sale. I am in possession. I paid everything.
No. After
it be decided there, he should not alienate. My Mr. Rodgi is in possession.
Mr. Rodgi is in possession, you are admitting.
Yes.
Yes, my lord.
And he will further alienate it, otherwise let the High Court decide.
1 minute.
Can
I
you
have to say
maintain-
something else.
Can you maintain the status quo with regard to possession? Let the 17 application be decided afresh.
So, my lord is perfectly right. I have no problem. I only want to tell your lordship one thing. Justice Datta posed a question. What did the High Court do about the sale? That was the lordship's question.
Yes, yes.
The answer is that, my lord, the DRT and DRAT set aside the sale by an interim application. In an interim application, the sale was set aside. So the High Court said, you can't set aside a sale in an interim application. That order is gone. Please argue your main case, and if you succeed, then the sale will be set aside, and that is now recorded in para 27 and para 30, my lord. So there is nothing which survives.
Friday,
And I will not maintain status quo. Turn to 1 minute, sir, if you don't mind. 1 minute, please. Turn to para 27. At this stage, counsel for the borrower submits that the respondent intends to approach DRT to amend the application. That is, my lord, for cancellation of sale. Respondent is liberty to do so. Court has not expressed opinion on the merits of parties. All questions open, para 30. All questions open before the DRT for on merits, my lord, because they will then argue not as an interim application. And only one more para, my lord, may see that your lordship will find paragraph 4 at page 4.
This is not the way, Manoj, with
1
respect.
minute, please.
He
Now,
intervened because
allow
I
me
had
to show
not...
I am doing something which will be in your favor. I will, my lord, not sell the property. That's what I am saying.
That's all. That's all that we are saying. We are not arguing. Why is my arguing also?
I want your lordship to record that, my lord, I have mortgaged the property. I will not, my lord, transfer or alienate the property without the leave of the court, and their main petition may be heard, in which they will re-urge, my lord, the question of fraud. That is the legal procedure.
That's all we are saying, Manoj. That's all we are saying for the time being.
That's okay. Then I'm saying something in your favor. What's the problem?
1 minute. I wanted this court to decide.
1 minute. Yes, Dr. Singhvi, what is your response?
I wanted your lordship to decide, but I think it's a fair suggestion. We don't want your lordship to waste time. Let it be decided by the High Court with a clear recorder.
Not the High Court. It is to be decided by DRT.
DRT. I'm sorry, DRT.
DRT.
DRAT.
Not DRT.
No, DRT.
DRT.
It has to be decided. Just one.
Securitization is in DRT, my lord.
There is a Section 17 application.
Yes.
High Court has granted liberty
DRT.
to borrower to amend the Section 17 application. After the Section 17 application is amended, the DRT will hear the parties and decide the matter. Till such time, the DRT decides the matter, we will record Mr. Rohgi's undertaking that he will not alienate, encumber or dispose of the property without obtaining the leave of the DRT.
Yes, correct. And
May I just make one submission?
One more thing. They have already, my lord, made an application for amendment pursuant to the impugned order, which was, my lord, yesterday.
Decided together, Manoj. They have decided together.
Very well. Mr. Gopal, you wanted to submit something?
One small submission. The Mr. Rohgi's client has mortgaged this property to the Punjab National Bank. The Punjab National Bank sought intervention in the High Court, saying that, look, we had no knowledge that there was this dispute pending and there was an order of the tribunals below. The problem is that now Mr. Rohgi can make whatever submission he wants. But since Punjab National Bank is not here before your lordships, making a similar statement, the difficulty is, would Punjab National Bank be in any way bound by this? Because as the mortgagee, they are entitled to take whatever steps is necessary. The reason why I am affected...
It's a hypothetical situation. Mortgage was created 2 years ago.
Mr. Gopal, one thing.
Yes.
One thing.
Yes.
Mr. Rohgi has mortgaged the property.
Yes.
We will record that in the event Mr. Rohgi's client defaults in making payment of the installments,
yes,
it shall be open to the Punjab National Bank to obtain the leave of the DRT
Absolutely.
and proceed under
Absolutely. No problem.
That's
no problem. And I will not let go of this property, my lord, just for default of the bank. I took a loan to purchase the property. I will not let it go like this.
Now, just the other point is only this, Mala.
Learned Senior Counsel for the petitioner in 36.1. Naam de dijiyega. Mr. Gopal Shankar Narayan, Learned Senior Counsel for the petitioner in 36. and Mr. Mukul Rodgi, Senior Counsel for the auction purchaser, within bracket. What is your name, Mr. Rodgi?
Yes. Milord, the name is Juana. R2, Milord, Juana Sanjeev.
R2.
Mrs. Juana Sanjeev Uppal.
Very well. Mrs. Joanna Sanjeev Uppal.
My lord.
R2. Right. Very well. The High Court of Bombay, by the judgment order, has set aside concurrent findings recorded by the Debt Recovery Tribunal, so and so, and the Debt Recovery Appellate Tribunal, so and so, whereby sale certificate issued in favor of Mrs. Joanna was set aside on the ground of fraud. Stop. While holding so, the High Court has granted liberty to the borrower and the landowner, represented by Dr. Singhvi and Mr. Shankar Narayan respectively, to amend the pending application before the DRT so and so under Section 17 of the Surfacing Act. All points have been kept open for the DRT to decide. Insofar as the sale is concerned, we do not find any specific observation having been made by the High Court, and it is this aspect that needs to be dealt with.
So, sorry, Milord, sorry for the interruption.
Yes,
the
sir.
High Court has set aside the orders of courts below, which had set aside the sale. So the High Court's order,
that
Milord,
means the sale revives.
Yes,
revives. And that is what the
therefore,
High Court should have addressed. It should have said something about this, that either the sale will abide by the result of the DRT.
That's correct.
That you will not alienate or encumber.
That's the problem.
It has said in para 30. It has said in para 30, Milord, then all questions are left open. It goes back.
No, that's not the point.
When the sale certificate is set aside by the DRAT,
my lord,
DRAT's order is set aside by the High Court.
Yes, my lord.
Sale certificate would revive.
Yes, my lord.
So where is the observation with regard to the sale certificate which now revives? You are not under any condition.
There is no condition.
You can
That is why his statement is vital. His statement
That
is
is
vital.
why we are saying this, sir. We are conscious that this is the limited point where the High Court should have made some
All right, your lordship may send it back.
You have submitted.
As your lordship pleases.
Right. We record the submission of Mr. Rodgi to the effect that Mrs. Joanna has mortgaged the property with Punjab National Bank, and that she intends to pay the installments on time. We also record Mr. Rodgi's submission till such time the DRT proceeds to decide the Section 17 application on merits de novo in terms of the order passed by the High Court. Mrs. Joanna shall not encumber, alienate, or dispose of the property without obtaining the leave of the DRT. This is also sustaining the liberty granted by the High Court, the borrower and the landowner have filed applications for amendment which are pending consideration before the DRT. This is correct narration of facts?
That's correct, my lord.
Yes. I just want to clarify, in fairness, the landowner, have not filed. Mr. Singhvi, Dr. Singhvi's client has filed.
Not landowner.
Yes.
Only the borrower has filed application for amendment of the section.
It's only his essay, my lords. No other essay. We are seeking implement in his essay.
And circumstances, we dispose of these special leave petitions, granting liberty to the DRT to consider the application for amendment of the Section 17 application filed by the borrower in accordance with law. The DRT shall thereafter be at liberty to decide the issue finally upon granting adequate opportunity of hearing to all the parties, including the secured creditor, which, in this case is Union Bank of India.
Union Bank of.
And the landowner.
Till such time, the DRT decides the Section 17 application, the undertaking given by Mr. Rodgi on behalf of Mrs. Joanna shall remain operative.
Grateful.
Stop. It is also made clear that should Mrs. Joanna fail to pay the installments on time and the Punjab National Bank wishes to proceed against Mrs. Joanna, it shall be under an obligation to obtain the leave of the DRT.
Grateful.
We reiterate that all points on merits are left open for the parties to urge before the DRT for a reasoned decision by them.
Grateful.
Deeply
obliged.
Yes, my lord, I am appearing on behalf of the petitioner.
The appeal has been dismissed.
My lord, here.
Co-accused appeal against the same order has been dismissed, madam. So,
My lord, it has served more than 15 years.
So that liberty
in prison, and identification is, my lord, only one thing. Identifications through TIP, which is vitiated, my lord. Kindly see page 70.
Said to be behind bars for more than 15 years, then that template order. Okay. 38.
I appear for a petition in this matter, my lord.
Yes.
But this is a 138 proceedings.
Sir, you have been let off leniently.
No.
Huh?
My lord.
Check is of 15 lakh plus and fine is
Yes,
only
lord.
6 lakh plus. Do you
My
want
lord, what has happened?
as to why
My lord,
you should
he
not be
claims,
sent to
my lord, that
prison? You want notice to be issued as to why you should not be sent to prison apart from fine? Sorry.
But I wouldn't want that.
Dismissed.
Grateful.
May I please? My lord, I am appearing in 39.
Yes.
Yes, my lord.
Yes,
My
Mr.
lord,
Singhi, para 14.
Yes, my lord. Para 14.
Reasons
Yes,
are given.
my lord, 44 lakhs is my annual return. And the income assessed is 25 lakhs a month, which translates to 3 crores as opposed to 44 lakhs. And my lord, this is on the basis that we are a family of Aligarh. I am having a big house in Aligarh, not in Delhi or in a metro, my lord. And my lord, we had 4 children. This marriage is of 23 years and 26 years. And 4 children, out of whom 3 I am bringing up. The 4th child is with the mother. He is a major. And my lord, this is highly excessive. I am spending a lot of money in bringing up my children. They are studying. My lord, 3 crores plus a car.
Maintenance, Mr. Singhvi. 3 concurrent findings are there. Why
Yes.
should we interfere?
My lord, this is really an assessment.
Out before the trial magistrate.
Pardon, my lord?
This stage.
My lord, kindly see.
No, not
Kindly
at this stage. Not at this stage.
My lord, just because I am bringing up my children in a good way, they are studying abroad, therefore to assume that, in fact, that should be a factor in my favor.
There are concurrent
How do I
findings
shed out
of
so
act
much money, my lord?
leading to award of interim maintenance to the respondent by 3 courts. In such view of the matter, we are not inclined to interfere at this stage, leaving all points open for the petitioner to argue before the trial magistrate. The special petition stands dismissed.
Yes.
Yes. Item number 40.
Well, I am appearing for the petitioner, my lords. Well, I am protected by Honorable High Court of Gujarat for all coercive method, my lords. And I appeared before the investigation agency. This is point number 2.
Proceedings are pending before the Gujarat High Court. Why do you come with a 32 petition?
My lords, on 16th of April 2026, after no coercive action protected by the Honorable High Court, they have freeze my 6 bank accounts
For the High Court, sir.
Additional bank account, my lords.
We will entertain a 32. Sorry. Dismissed with liberty to approach the jurisdiction.
I am withdrawing it.
Very well. Dismissed as well. Forty-one, last day also nobody appeared. Huh? 41, anybody? Any or a second call maker? Pass over.
My lords, 42 is also a foreigners tribunal matter.
Foreigner tribunal 42. 43 adjourned as per letter.
44.
44.
44, my lord, Mr. Vikas Ranjan Bhattacharya leads us, my lord.
Yes.
And I am with him, my lord. I'll make the second submission. There are I think 4 or 5 matters.
Well, we are for the respondents.
Main matter for the respondents, my lord. We are for the caveator.
We are for the caveators.
We are for the
I appear for the.
We are for the caveators.
Mr. Gupta for?
I appear in point 1, my lords, for the petitioner.
Argue for the petitioner.
I'm sorry, my lords.
Very short plan that the Honorable Court did not really go by the principles of Article 14 and 16 when there is a basic allegation of institutional fraud. The learned judge records anyway the appointees are not responsible, but that cannot be a ground to uphold the appointments which are made absolutely in violation of law and on basis of the money. There has been a CBI investigation. CBI investigation noted huge crores of money were exchanged for the purpose of this appointment. Now, this requires consideration by this Honorable Court.
But we have been working for 9.5 years now. There are no allegations against any individual.
We are not passing any interim order at this stage. But today, if the allegation is this, that the candidates who have been appointed, they do not possess essential qualifications. What will be the
Well, it is not the
effect of it?
There is no such case.
This is not correct.
This is pertaining to appointment of primary teachers.
Yes.
Correct.
2016, the process was initiated. We would like to know, after the primary education board is served with notice, how many of the selected teachers had TET?
Yes.
That is, we had.
All of them.
We are all qualified. We are all TET.
If all the
record be produced, it will be happening.
Kindly see the advertisement.
We are all TET. If I can just respond.
Mr. Bandyopadhyay, if the advertisement does not say about TET qualification, that does not take away the rigors of section 20.
We all have TET.
We have
all of them, they have TET.
All of you have it.
TET is not the point, but we have all active ballot after participating. Can you ballot?
I appear for the board.
The only point which was agitated.
Touching your appointment right now.
Till their error.
Touching your appointment right now. You
Kindly
continue.
come. All right, let the court decide.
Say that
The petition was filed after 5 years from the expiry of time.
segregated ballot. It is not like the SSC matter where the CBI couldn't segregate.
Kindly come to page 308.
Anybody, today, if anybody is found 5 days prior to his superannuation that he did not have the essential qualification,
Please,
do you mean to say that the employer has no right to terminate his
All of us have, my lord. That's the essential qualification.
Qualification is not an issue here, my lord.
Not possible.
Everybody has
In better times,
Can you come to page 3081? Can I request kindly come to page 3081?
One submission.
Is it
Mr.
hearing today?
Mr. Bandyopadhyay and other learned senior counsel, can you have any right of audience at the stage of issuing of notice?
No.
I only had a suggestion. That is all right, but your
If you don't have a right of audience, please
your lordship
bear
is
with
making
us.
an observe. What I am
Your
saying.
counters, we will consider. We have not issued any order of stay. If you were to issue an order of stay under 148 capital A, you definitely have a right.
Only one request. Your lordship is making one observation. One observation, which I am quoting. Observation is not correct. Kindly let
Our endeavor is to find out that our children are taught by people who are duly qualified.
Certainly.
We cannot have any objection there. So
No,
what
certainly not.
if we endeavor to find out whether the teachers whose appointments were cancelled, whether they had the basic qualifications or not, stand in the way.
Can I suggest? That's the reason I am requesting to your lordship kindly come.
An early returnable date. Early returnable date.
Yes, that is it.
May I make one submission, my
Early
lord?
returnable date.
Consider early or later on. It will come after the partial working days. It cannot.
All right, in July or August, your lordship may keep it.
Let them accept the notice.
something.
Formalities be waived.
Can I
Whoever
make a
is on
short
caveat, service need not be affected, dispensed.
Yes.
But
Milord, I also appear in caveat.
Service on the primary education board. And whoever is public official,
We are here, my lord.
have to be served.
Primary education board is here, my lord. We'll accept service.
Mr. Gupta is here.
Your
The
lord-
primary
your lordship put a
education board, I
question, my
believe.
lord. Your lordship put a question. They are all TET trained, my lord. That is not a problem, my lord. Your lordship
Then
wishes to
we'll
hear the
consider
matter, we'll
that.
file.
First,
make a table, man.
satisfy ourselves.
Yes,
Your Lordship, just one other point on notice. We are all caveators who are appellants before the High Court, but our
Well, imagine that if we have to encounter this at the notice stage, what will happen after the final year?
Yes.
members of the discussion, Your Lordship,
Let the records be disclosed.
Petition was not maintainable. 32,000 teachers without being heard, they were
only running
Lordship, we are caveators who are appellants before the High Court.
One sees paragraph
Lordship, we are caveators
190
who
where
are
the
appellants
CBI
before the
has
High
said that
Court,
we are not
but the
the
appeal
group
is
of
not being
persons.
filed in
My
our
lord,
one
may I
case.
make one
Out of
submission?
44 appeal has been filed in one case.
We are all appellants before the High Court.
But I think once your lordship has issued notice, we'll come back in July, my lord. I don't think this is really necessary today.
In better times.
Yes, my lord, we will file in July. Your lordship will hear us in July. There's no
Yes.
Opening statements which were made, the impression which was given to the court was totally wrong.
Released in the third week of August.
My lord.
Third week of
August.
We may also be allowed to file counters, my lord.
Everyone.
Caveators? Caveators?
Everyone to file counter, whoever is served or whoever is appearing on caveat. Yes, next.
My lord,
45.
45, I beg to appear for.
Madam, is there no intra-court appeal available before the Allahabad High Court?
My lords, there is, my lords.
Item 45.
There is, my lords. I'm sorry.
Then why have you come directly?
I am sorry, my lords. I did not even notice this. Would your lordships record my statement?
I'll tell you
and
why.
permit me to-
The limitation is 60 days. 60 days. And you have already crossed 600 days. So you thought, let us take a chance before the
My lords,
Supreme.
I apologize. Your lordships may record my statement and permit me to go back, my lords. I
All
apologize.
right.
Madam seeks leave to withdraw this special leave petition with liberty to file an inter-court appeal before the High Court. Permission granted. Liberty as paid.
I'm grateful. my lords.
46.
Lords, may I seek a password, my lords? Please, my lords.
Passover. Yes.
Please, my lords.
Passover 46.
So I appear for the petitioners in 47. This is the Axis Bank regarding the deposit of large amounts of money.
Mr. Gopal, you will have to deposit the money with the registry.
No, I'm the petitioner. I had to accept the money from the person who was depositing.
Right. So you are now the petitioner appellant before us.
Yes, but that money has never been given to me. So if
given to you,
will deposit
but
it,
the
we'll
direction is that you will have to refund.
Yes.
So if you want a stay of the order, we are putting you to terms.
Very well.
Getting the stay order, you will have to deposit this 3 crore 19
right
with the registry.
Very
May I, Lordship, with your indulgence, Lordship, that we may be permitted to withdraw the amount subject to bank guarantee? No, 1 minute, Lordship. I'm just simply saying subject to bank guarantee.
Mr. Kohli, you have to decide this matter. Your money was not accepted across the counter.
Then Lordship may hear me for a minute.
Lordship may hear me only for a minute. You will get back the money. They are keeping it in deposit.
Lordship may hear me only for a minute, only on a limited point. We never challenged demonetization. The holding is quite correct that they unilaterally prevented me from depositing. The only mechanism I had to deposit if I was KYC, I was KYC. And therefore, they create an internal policy in derogation of the RBI's directions. So therefore, Lordship, I've been denied my opportunity.
Your money will be saved, but it will not be given to you.
The appeal is admitted. Stop. For a period of
interest-bearing FIR, Lordship.
There shall be unconditional stay of the order under appeal. Stop. If within this period of a month, the appellant deposits rupees 3 crore 19 lakhs 58,500 in the registry of this court, the order of stay shall continue till the disposal of the appeal. Should there be a default, the order shall stand vacated and it shall be open for the respondent to have the order executed before the NCDRC by instituting appropriate proceedings. Stop. Upon the deposit being made, the registry shall invest the same in a short-term interest-bearing fixed deposit account on auto-renewal basis and shall keep the account renewed until further orders to the contrary are passed by this court.
May I make one small submission?
Within 4 weeks, we joined that, 2 weeks thereafter.
Just one small submission. We'll do this. The amount which was held by them in cash, we are unaware of what has happened. RBI has sustained our position, who is our regulator, saying during the demonetization period, if you start getting trickles of cash, 20 lakhs, 12 lakhs, 99 lakhs, we accepted the first 3. The fourth one we didn't accept because we said, where is this money coming from? Give us the source. They never.
Lordship, I can answer that.
That is our stand.
I can assist, Lordship.
Just a minute.
Lordship, we were under protection of the Supreme Court because we had multiple rounds of litigation are there. There is no such thing about a trickle apparel. It was as many times as much as you could deposit it KYC.
At the final hearing.
Very well. Because their cash, we don't know what happened to it. It's all old notes.
Yes.
That should have been.
It's not about old notes. This is about deficiency of service. It's not demonetized.
48.
Grateful, Lordship.
Yes, 48. 48. Yes, solicitor.
I'm in 49, Manoj.
Oh, you're in 49. Then who is in 48?
No, sir. I think
I'm
48 in this.
My apology, my lord. I'm in 48.
NTPC.
There is some confusion. Kindly pardon me. But this is a neat question of law. Interpretation of section 28 of the new Land Acquisition Act. Please have, my lord, page 26, where the provision is quoted.
26.
At page 20, it starts at page 25. I might read, my lord, the whole so that your lordships, I can give the background, my lord. Determination of market value of land by collector. The collector shall adopt the following criteria in assessing. And, I'm sorry.
1 minute. Yes, now you can proceed.
Yes. In assessing and determining the market value of the land, namely, A, the market value, if any, specified in the Indian Stamp Act, we are not concerned. Lord, B, we are concerned. The average sale price for similar type of land situated in the nearest village or nearest vicinity area. Or C, we are not concerned. whichever is higher, provided that the date for determination of the market value shall be the date on which the notification has been issued under section 11. Now, please see explanation, my lords. Explanation 1. The average sale price referred to in clause B shall be determined taking into account the sale deeds or the agreements to sale registered for similar type of area in the near village or near vicinity area during, please mark this, my lord, immediately preceding 3 years of the year in which such acquisition of land is proposed to be made. My lord, proposed to be made is section 8 of the Act. That is, my lord, the proposal. And my lord, there is a purpose why, my lord, this is provided for. But for which, my lord, I rely upon the standing committee report. When this act was being enacted, my lord, they have said that once a proposal is put in public domain, people start selling their lands. And therefore, that would be the right criteria to be taken into consideration. While, my lord, if your lordship permits, I can screen share, my lord, that part of the report. Only one, my lord, report is, one part is to be submitted, my lord. Your lordship, the court master may have to permit, my lord, screen sharing.
So in this case, you proposed acquisition in 2016?
Yes. But
a preceding 3-year period?
Yes, my lord. The section 18 is 29th April 16. Your lordships are right. So, my lord, it could have been 3 years prior.
2013.
Correct. But the court has, my lord, held that it would be from section 11 notification 3 years.
No.
That is, my lord, page 30.
Where is that finding?
Page 30, my lords.
No, paragraph 30.
No, page 30, para 22. My lord, which is contrary to, my lord, what was the intention? My lord, this was a issue which was debated, that the moment section 8 notification comes, there are transactions. Your lordship gets para 22. Can I read with your lordship? This court is of the considered view that the arguments advanced by learned ASGI appearing for NTPC Limited are devoid of any merits on account of the following reasons. On the point of taking 29th April 2016, well, that is section 8, as cutoff date for computing the period of preceding 3 years to determine market value of the acquired land for payment of compensation. If the argument of NTPC Limited that the preceding 3 years for determination of market value is to be related to 29th April 26, when fresh application for initiation of land acquisition proceedings was made after proceeding lapsed under the old act, is accepted, it would lead to a situation that the 3 years prior to 29th April would be taken into consideration for determination of market value on the basis of issuance of notification under section 11, which is in the present case is 12th June 19. If such argument is accepted, it would lead to a situation that any sale deed from 29th April 2016 till 11 June 2019 will not be taken into consideration to determine the market value as on the date of notification under section 11. Such is not the intention of the legislature. The legislature has clearly and unequivocal words provided under section 26 itself that the date for determination of market value shall be the date. So when I am computing it, it will have to be today.
But sir, if you issue the 11 notification in 19,
yes,
that is the proposal for initiation of land acquisition.
No, my lord, the proposal is section 8, my lord, if your lordships can see.
2013 Land Acquisition Act.
2013. And if your lordship permits, I'll screen share the report of the standing committee.
Fair Compensation Act, 2013.
It's a right to fair compensation and transparency in land acquisition, so and so. Act.
Section 8.
8, my lords. Possibly page 15 in your lordship's copy, my lord. We have the same. Examination of proposals for the land acquisition and social impact assessment report by appropriate government. The appropriate government shall ensure that, your lordships can skip. 2. The appropriate government shall examine the report of the collector, if any, and the report of the expert group. Your lordships can skip. 3. The decision of the appropriate government shall be made available in local language to the panchayat, municipality, or municipal corporation as the case may be, and the offices of the district collector, subdivisional magistrate, and the tehsil shall be published in affected areas in such manner as may be prescribed and uploaded on the website of the appropriate government, provided that where land is sought to be acquired for the purpose as specified. But we are not concerned with that. That may not assist your lordship either way. Lord, kindly see. I just read.
Mr. Solicitor, there has been a gap of 3 years.
Yes, my lord.
If you say that proposal is in 16, Section 11 notification is in 19.
Yes, lord.
Now, if it is more than 3 years, say, let us say 5 years, 7 years, then the entire object of this act gets frustrated.
Lord, the object we will get,
as the High Court has correctly held, within that gap period of 16 to 19, whatever sales take place would be rendered insignificant, inconsequential.
It can also be taken into consideration. Law provides prior to Section 18, Section 8. My lord, may I just read? My lord, I am unable to hand over the copy.
Proposal would be for a different purpose. This proposal would not fit in.
Lord, can I read, my lord, the report?
Such acquisition of land is proposed
Lord,
to be.
Can I circulate the report of the standing committee?
So far as the authority is concerned, who is acquiring and for whom it is being acquired. But so far as the public at large, 11 is the proposal. It cannot be antedated to proposal.
11 is not the proposal. My lord, 11, please have a look at, my lord.
No, 11 is a proposal in the sense, if we go back to say
Section 4. Section 4.
Section 4. 5A.
Yes.
If I give a valid objection, your proposal does not go forward if my objection is accepted. So 4 is a proposal stage.
Lord, may I just, Lord, read? I am unable to hand over. Lord, this might need examination. I may succeed or fail.
No. In a proper case, you argue. But this one,
Lord, can I read? Lord, for my satisfaction, can I read?
Decimal entries. No, sir, not in this case. Not in this.
Lord, can I read, my lord, the report of the standing committee?
We are not prepared to accept that 8th proposal is the proposal referred to in Section 26.
Lord, can I, my lord, read for my satisfaction? It gives a direct answer.
Read it.
My lord, I am sorry, my lord, if your lordships can allow a screen sharing.
My lords, I may go by the plain words of the statute. We will not go by any committee report now.
No, my lord, this is the committee report based upon which the act was made.
Maybe, but it is an external tool.
I'll just read. My lord, please allow me to.
If the language of the statute is plain and clear, why should we adopt tools of interpretation?
May I read? My lord, your lordships may take that call, my lord, a little later. Can I read?
If there is a proposal, the social impact assessment report, if it takes 2 years to come, thereafter government takes another 2 years to consider the social impact assessment report and then issues the 11 notification. Why should this sale transaction in between?
Section
when people may not be knowing that it is under acquisition proposal, why should it be?
May I, my lord, unless your lordships allow me to read, maybe I'll not be able to, my lord, bring forward my point.
Please read.
May I read? On suggestion of the government of, this is, my lord, the Standing Committee of Parliament, discussing this particular bill, which become an act. On suggestion of the government of Madhya Pradesh regarding application of clause 11.4 of the bill that seeks to ban all kind of land transactions of the appropriate land before SIA is considered. That is, my lord, social impact assessment is conducted so as to, I'm sorry, my lord.
Yes, please continue.
No, your lordships would not get it in the file.
No, we are not. No, I know that it's not in the file. You said so.
SIA is conducted so as to restrain mischief mongers from artificially ballooning the prices of land. The DOLR stated that a social impact assessment needs to be conducted before notification under clause 11, however, to contain, please mark this, artificial inflation of prices, a calculation of market value in clause 26, the time of period of preceding 3 years should be taken into account from, by kindly mark, the date of SIA notification. This is what, my lord, was contemplated by the standing committee. My lord, kindly allow me to, my lord, place this on record. My lord, this would apply, my lord, pan India. My lord, kindly allow me the genesis, the very foundation on which the act came into force. They say that
if the authority takes 5 years for the issuance of the 11 notification, anything done in between will be rendered redundant.
Then explanation 1 will become OTOs.
No.
Explanation 1 will become OTOs.
The Act should have made it clear what is meant by proposal. It cannot be just referred to Section 8.
Well, that your lordships will necessarily get, my submission is from the standing committee report.
No, sorry, sir.
Well, would your lordship say question of law is kept open?
Question of law is, you want that?
Yes, my lord. In facts of this case, my lord. Because there is genuinely, my lord, it's an arguable case. Now that your lordships have dismissed, I am saying it is an arguable case, my lords.
But Mr. Solicitor, if we pass a single one-line order, that doesn't mean that the Supreme Court has upheld the order of the High Court on. It's absolutely open to you.
Lord, better not to leave it to others.
It's a single bench order.
My lord,
in some other High Court, it may have been only of a persuasive value.
my lord, better not to leave it to others to interpret your lordship's order.
We are, in our judicial academy, we are deliberating on this. Let us tell you, a single judge takes enormous effort to write a judgment. 15 pages. How much time does it go behind writing a 15-page judgment? At least 2 hours in chamber. Matter comes up before a division bench. Division bench takes another 2 hours at the residential chamber to write its own judgment, affirming the single bench order. Matter comes up before the Supreme Court, and we say, not a question of law is kept open. What happens to the judicial time that is wasted there?
Lord, I may not have any answer to that. Would your lordship say in facts of the case?
Yeah. So therefore, we will have to keep the question of law open only in those cases where there is doubt evidently, palpable on the face of it.
Would your lordship say in facts of the case dismissed?
This is not such a case. So one line dismissal.
I'm not insisting for.
There is no merger. There is no merger. That judgment is open. You go in a similar case and say that it doesn't mean that the Supreme Court has affirmed the judgment of the Jharkhand High Court. It's
only one, but I'll not request for question of law. Would your lordship say in facts of the case?
Nothing more. We are not inclined to interfere. Dismissed.
Please, your lordship.
Obliged.
Yes, 61.
Lord, item 49. Lord.
Now we are on 61.
May it please.
Oh, I see. 49, perhaps post notice.
Yes, the Lordship will go after vacation. I'll tell Lordship why not. This is that matter regarding that MSME. The latest RBI circular has to be shown to your Lordship. That's why. I don't know when your Lordship will take it up. Or shall I wait? Whatever.
If you are not available, we will keep it after vacation.
No. I'm available. I'm fully available, Lord. I'm not waiting.
We want to finish up the fresh matters.
All right. I'll wait.
Post notice matter.
I'll wait.
Yes, item 61.
May it please.
On the petitioner and the High Court dismissed the matter because to consider the allegations on me and direction to the surrender before.
Amanullah.
Yes, my lord.
complaint case.
My lords, exactly. So, my lords, Om Prakash versus State of Jharkhand, my lordships, as early as April of this year, has clarified that in complaint cases, the summons has to go. It is only if the summons doesn't go that there are other processes to be followed.
If he is appearing before the court, where is the question of an apprehension of arrest?
Exactly, my lords. However, my lords, in this case, what the impugned order does is that the impugned order dismisses the anticipatory, but it also says that the SP will arrest if he doesn't surrender.
That is
And
not
my
proper.
lords is, in my respectful submission, my lords, erroneous because
What is the citation of Justice Patiwala's order?
2026 SCC online SC 676.
Very well. Leave granted. The impugned judgment and order is in the teeth of the judgment and order of this court, reported in so. Accordingly, the impugned judgment and order stands set aside. We make it clear that the appellant shall appear before the trial court on each and every date fixed for trial unless exempted. Unless exemption is granted in accordance with law.
Grateful, my lords. Would my lords permit me to give my appearance in the chat box?
Just before the court, no coercive steps shall be taken.
I'm grateful. My lords, could I give my appearance in the chat box, please?
Yes, yes.
I'm so grateful.
Item 62. Yes, Madam Prakash.
My lord, it appears that a land dispute has led to institution of 3 cases. One,
Notice.
I think we've lost the connection.
Notice interim. 63.
My lords, it seems, my lords, the order is, despite my lord's order, no cognizance has been taken by the National Commission to, my lords,
tomorrow, sir.
My lords, still, my lords,
I accept notice on behalf of the state in item number 62, my lord.
Yes, 62, Mr. Counsel accepts notice. File your counter. Rejoinder.
Yes, sir.
Come up in the 3rd week of August.
Yes. My lords had passed an order in September. Despite that, my lords, no effective steps were taken, my lords. And my lords, this is not only in this matter, in every matter, my lords, the execution is not moving, my lords. And we are at a situation where, my lords, CC complaint takes 2 years, execution is taking 4 to 5 years now, my lords.
What can be done?
What can be done?
What can be
My lords,
done?
I think guidelines have to be followed. Rahul S. Shah, my lords, had laid down guidelines.
There are guidelines given by this court. Even then, the tribunals are not being able to abide by what? How can we say that they are not trying?
My lord, because after my lord's order, even 70 did not start the section.
How many cases are there and how many courts are functioning? All these things have to be taken into consideration.
My lord, 6 hearings after my lord's order, yet my lord, no cognizance has been taken. That is after my lord passed an order in September to conclude it by March, my lord, still no cognizance was taken.
Is fixed before the NCDRP tomorrow. In such view of the matter, we are not.
My lord, keep it in a time bound manner, extend it by 3 more months and say even close in 3 more months. That is, my lord, can be done.
To the petitioner to persuade the NCDRC to close the execution case as early as possible in terms of the earlier order passed by this court, as well as the order dated. Well, you have the citation of Justice Patiwala's order that all execution cases should be disposed of within 6 months.
Yeah, my lord, yes, that is Rahul S. Shah, the earlier judgment.
Just send it to the court master.
I'll send it to the court master.
Yeah.
I'll send it to
Yes. Next.
Grateful.
Item 64.
Dismissed.
Very well. Mr. Diwan, we can't hear you.
Is your lordship able to hear me?
Yes, loud and
clear. I can't have clean.
No. This is not okay.
No,
Okay.
again disruption.
Where's your volume? Can your lordship hear me?
Yes, yes, we can hear you.
Where's your volume? Can your lordships hear me this time?
Yes, sir, we can hear you.
Yes. So, Manoj, may I just make the point? I apologize that we've been having some trouble with the.
You can use this.
No, just
you can use this. No,
Again, there is a disruption. Huh?
Manoj,
There is a network issue.
I think the problem may be at my end. I apologize for that. Your Lordships can now hear me.
Yes, yes, yes.
Yes. May I just state the point? This is an issue which, according to us, raises an important question of law. And the issue is really the interplay between sections 9 and 9A of the Minerals Development and Regulation Act. Now, I'll just tell your Lordships what has happened. And please, may I do so with reference to the impugned communication, which is at page 577, 578. Your Lordships also have the Mines and Minerals Development and Regulation Act available. We had sent it to the court master.
Yes.
Your Lordships have 577, 578?
Yes, 577, we have it.
Yes. Now, this is the impugned demand which I was constrained to challenge. Now, this demand, your Lordships will see, is in respect of royalty, payment of royalty, third line in the impugned communication, and also subject. The Lordship has that. Now, royalty is referable to Section 9 of the Act. And Section 9 mandates that the royalty would be liable on removal of the material or on consumption of the material. So until there is removal or consumption, there is no levy of royalty under Section 9. However, there can be a levy of dead rent. Just keep this concept of dead rent just separate under Section 9 capital A. Now, there is, in the facts and circumstances of our case, the removal started only after the consent to operate. There is a mining plan approval. The mining plan approval granted by the central government mandates that you cannot operate this mine until you have until all the environmental permissions are received. And in the facts and circumstances here, those environmental permission would be the consent to operate. So just keep that in view. I have, once the consent to operate was issued to me, been paying royalty. So there's no dispute on that at all. What the impugned demand does is that it seeks to impose royalty, demand royalty, for a time before I had the consent to operate on a notional basis. Now that cannot be done because the statute contemplates that until such time as there is removal and consumption, you have to pay dead rent. And here your Lordships may note that I have been paying dead rent throughout the requisite period and there is no demand for dead rent. Now, may I just, we have sent it to the court master, the sections. May I just place the sections before you? So your Lordships have it because there's an interpretation issue here. Section 9, first.
Why did you take the trouble of sending the entire act in a paper book? We have the enactments with us in court.
We'll keep that.
This is sheer wastage of paper.
Oh, I'm so sorry. So would your Lordship just take up section 9? We are concerned with 9.2.
9.2.
Your Lordship has it? Royalties in respect of mining leases?
Yes.
Yes. Now I'll take you straight away to 9.2. The holder of a mining lease granted on or after the commencement of this act shall pay royalty in respect of any mineral, now mark the words, removed or consumed by him or his agent, manager, employees, contractor or sublessee from the leased area at the rate for the time being specified in the second schedule in respect of the mineral. So your Lordships have seen it has to be on the mineral removed or consumed by him. Now, in my case, the consent to operate, your Lordship may just note that date, the CTO was issued in my case on 26th October 2023. 26th October 2023. And I have been paying royalty at the requisite rate from 26th October 2023. Now, what is to happen before that? So there is a provision in the statute for that as well. And your Lordship will find that in section 9, capital A.
Yes.
Please take up 9A. There's a separate statutory notion of dead rent. Dead rent to be paid by the lessee. The holder of a mining lease, whether granted before or after the commencement of the Mines and Minerals Development Regulations Amendment Act 72, shall, notwithstanding anything contained in the instrument of lease or any other law for the time being in force, pay to the state government every year dead rent as such as may be specified for the time being in the third schedule for all the area included in the instrument of lease. Now the proviso is important. Provided that where the holder of such mining lease becomes liable under Section 9 to pay royalty for any mineral removed or consumed by him or by his agent, manager, employee, contractor, or sublessee from the leased area, he shall be liable to pay, please mark the words, either such royalty or the dead rent in respect of that area, whichever is greater. Whichever is greater. So it's one or the other. Now, please have a look as to what, let me just indicate as to what the collector has done, and in our respectful submission, done erroneously. So your lordships has seen that impugned demand. It's at page 577, 578. Please have a look at that.
Is it for a period prior to the CTO?
Yes, it's for a period prior to CTO. So just have a look at it, please. Page 578.
CTO or no CTO?
Yes.
There's a payment schedule in which says that it says this minimum production requirement. It says that first year 0.
Correct.
You're not required to take out any mineral.
Yes.
Second year is again 0.
Yes.
And it gradually increases.
Yes.
Even if the production is 0, you are not having a CTC certificate, you are required to pay the dead rent. Because when the production is 0, there cannot be any royalty.
No, so may I just note, your lordship is absolutely correct. Absolutely correct. So that's exactly my case. My case is dead rent liability is there and I have paid the dead rent liability. So there is no demand for dead rent. That's exactly my case.
I am liable. Not.
The impugned demand is for royalty. That's the problem.
Suppose that it is prior to obtaining the CTO.
Yes, your lordship will see that from the demand itself.
Where is that?
Would your lordship like to have a look at the CTO? It's at page 486. It is dated 26th October 23.
486.
Your lordship has 26th October 23.
Yes.
So this is my consent to operate.
Yes.
So your lordship has noted the date, which is most important for our purposes, 26th October 2023.
Right.
Now, please see the impugned demand at page 578. He's starting the impugned demand from 1st April 22. I'll explain to you how. 22-23, and then 23-24, and then 24-25. I have paid royalty on and after the CTO date. Now, how has he gone about it? So I have also paid dead rent for the earlier period, so there's no demand for dead rent. Now, the High Court has confused itself and said, followed a precedent of dead rent for the purposes of royalty when the concepts are statutorily completely distinct. Now, please have a look, if your lordships would, as to how the collector has proceeded. This is on the basis of page 309, which is the erroneous basis.
P09.
Yes. May I, with your permission, before I take you to that, just show you 107, please, and then I'll take you to 309 right away. Just go to 107. 107, annexure P5. Now, this document at 107, 27th November 2019, is what allows me to proceed because it's my approval of the mining plan for my mine. Please notice this. Subject, this is from the central government. Approval of mining plan submitted by you for grant of mining lease for so-and-so limestone deposit.
Please wait, please.
Yes, certainly.